have intellectual property law review addition to ISSN 2003 to 2390. She also, as a student, has been a part of summer school by the World Intellectual Property Organization and University of Geneva. Currently, she is working as a research officer with Central Electricity Regulatory Commission, Ministry of Power. Heartiest welcome to you, ma'am. I now request you to please proceed with the session.
Where did it had its roots from? What are the ways through which intellectual property can be commercialized? How intellectual property can actually be managed? A case study and final takeaways, and then we can have a question answer session. So, beginning with the definition, commercialization is where intellectual property is used for a return, like it can be in cash, in kind, any kind of free compensation. So I would like to press my thoughts on firstly the theories, the jurisprudence behind intellectual property. So for protecting intellectual property, there were like different theories, and intellectual property was protected in that way. Like the very first theory was the sweat of the brow theory. It said that if anybody is making any efforts to protect the intellectual property, then that person needs to be decompensated for it. For instance, if I am a writer and I am writing a poem on something, so I am applying my labor, my thought, protecting it in a tangible medium. The other theory, which is conflicting to this, says that in a property which is created, like if a medicine is created, like let's say we have a medicine for COVID, and it has its patents. So the other theory is the welfare theory. Welfare theory says that all the intellectual property must be present in the public domain, so that the public at the large can use it in a way which is for the welfare of the public. So now there are two conflicting theories. The first is the sort of the broad theory, second is the welfare theory. So commercialization of intellectual property has its roots balancing the both, in my opinion. So through commercialization, what we can do is we can incentivize the original creator, the author, the patentee, whoever the person is, for their efforts. But in the second case, we can make the intellectual property available in the public domain for the public welfare. Now, I want to pose an example to it. Let's say that there is one company in America, I don't name the company, they make wind turbine motors. So they have the exclusive patents to it. But India will become the worldwide developer, generator of 100 gigawatt power in the next 2030. So we need those industrialized machineries, those specialized motors to be there to generate electricity. But now the issue arises that the patent of those motors is with that American company, and India needs those motors. So what we can do is license their technology to our country through commercialization, so that they get incentivized out of their own idea, but we reap the fruits of the creation. So commercialization is nothing, in my opinion, but it is just management of intellectual property in a way where the rights and the welfare of the people can be balanced by incentivizing the original author of the property. So, any discussions? Anybody wants to say something? Any brainstorming on this? Any opinions? Should I move ahead? Okay, I'm taking it as a yes. So now I will try to explain in